for the short-term property owners. They said that the City of Austin's ordinance unconstitutionally violated the property right to lease property, unconstitutionally infringed on a fundamental right to assemble, and the city failed to narrowly tailor the regulations to achieve a governmental interest. That's an important issue we can talk about some other time. But the Texas Supreme Court ultimately denied the petition for review. So what happened is, in this case, the short-term rentals won on the appeal, and then the city of Austin appealed that to the Supreme Court, and the Supreme Court denied the review. So what does that mean? That simply means they did not really have any issues with what happened at the appellate court. That was sort of a message from the Supreme Court on their feelings on this issue, okay? So now we fast forward to 2021, a very recent case. This is Draper versus the City of Arlington. Again, it's an appellate court case. And this is now Dallas. So this is the City of Arlington. City of Arlington has short-term rental ordinances and standalone and zoning ordinances. And what they did is they established short-term rental zones near entertainment venues, sort of pods that you would have throughout the city, and said, if you're going to do a short-term rental, you can be in these zones here. And then they actually created a buffer around those, about a 1-mile buffer, where you couldn't be in those areas either. And well, they limited the number in the buffer area, and they limited the number in the zones. Anyway, long story short, short-term rental plaintiffs argued that the ordinance violated their constitutional right of substantive due process and protection from governmental interference. The trial court ruled in favor of the City of Arlington, and the appellate court affirmed. Now, this was the first time you actually see an appellate court coming in and actually siding with the property owners. Now, why did they do that here but not in the other cases? Well, the court gave deference to the city because their arguments were based on studies and support findings. One of the things you have to have when you have a governmental regulation, there has to be a nexus. So what governmental interest is this government trying to accomplish? And is there a nexus between what you're trying to accomplish? And it's not just an arbitrary rule. Well, in this case, the Arlington had studies to prove what was happening in their city, whether it be crime statistics or whatever that may be to support their regulation. And in this case, the court gave a lot of deference to that and said, we're going to support the property owners in this. So now that creates the big question is, now that this case, if it's appealed, in this case by the short-term rental community, if they appeal that, will the Texas Supreme Court grant the petition for review? Because this sort of contradicts the two prior cases that I just mentioned, Zadatari and Tar. So the legal landscape in Texas, as you can see, it's uncertain right now. But don't get me wrong, there are many communities and there are many short-term rental ordinances, and many of them have been challenged. And I think Councilmember Little explained probably why that's the case in some communities, why there aren't challenges last time. And I think he was accurate on that. It costs money to do these lawsuits, to take a case like this through an appellate court to a Supreme Court. And typically you see communities, again, Dallas, San Antonio, Austin, very big demand for these types of rental units in those communities. And then, of course, we are close to a larger community, and so there is a demand, but not as big here as, for instance, in some others. All right. I apologize for the long explanation on those three court cases, but I thought it was important to at least understand what we're dealing with. So regulatory efforts, again, what can be done? What types of things can you put into ordinances? And these are some of the different tools that you'll see. Some cities will actually come in and do an absolute prohibition and basically say, challenge somebody to sue them. They'll use zoning, registration, permitting, licensing, inspections for safety, things of that nature, occupancy limits, vehicle limits, advertising rules, safety brochures, notification of registration to neighboring properties. In other words, if you come in and license, you got to give notice to your neighbors who you are and give, for instance, possibly give contact numbers and complaint lines and things of that nature. And then the ordinances like this typically will have some type of revocation and appeal procedure for any registration, licensing, and permitting. There are others. I just wanted to give you an idea of what you see in the different ordinances. Some of them are very basic. Some of them are very complex. But again, these are just some of the tools. Okay, we can go to the next. So this is the last slide, and what I want to mention here is what happened more recently. Whether you have an ordinance or not, you can have somebody come in and register. You can deny their permit. But if they continue to do what they're doing, despite that they don't have the right to do it, but they continue to do it, the city's recourse through that ordinance is very limited at that point. Then you have to step outside of that. And we do have a tool. We can actually file a civil lawsuit against an individual who's a violator of that. And that we use it's Texas Local Government Code, Chapter 54. And what it allows us to do is file a civil lawsuit for people who violate city ordinances. And when you do that, we're entitled to a couple of forms of relief. One would be injunctive relief, where a court would come in and direct them to stop doing this, okay? And issue an order to stop doing it. The other thing we're entitled to is civil penalties, up to $1,000 per day for each day that the person's violating. More recently, we did do a case on Verona, and the court reissued an order, and in that particular instance, have issued a fine right now of civil penalties of $30,000 and have ordered the property owner to stop. And in that particular case, if they don't do so by a certain date, there will be $78,000 added to that. And then, of course, failure to comply would render the individual possibly in contempt of a case. So these are tools that you have, but I just want to make sure everybody understands a short-term rental ordinance doesn't address a blatantly bad landlord. We have to use other tools for that, and that's what we've done more recently. I just want to make sure that's clear. So hopefully this background information was beneficial to the council and to the public, and I'd be happy to answer any questions y'all may have about that, but I know you'll have other information to discuss as part of this item.
Yeah, I think that's a good starting point for what we have to put together. It's not going to be be all end all type of draft. It's just not. It's not going to take complete care of all the bad actors that are out there. And I will say this: there are plenty of people who are doing short-term rentals that we may never. Just if you go down the street, you'd never know they exist. They're doing it the right way. It's quiet. It's someone coming in for, a night or two before they hit a cruise down south, or they're coming in because they're a patient in the medical center and they just want to spend a few nights away from the city rather than where they get all their treatment done and everything else down there. And so I think the vast majority of STRs probably fit into that. Unfortunately, though, and I said this in a previous meeting, whether it's a football game or a basketball game or out in society, laws and rules are written for the bad actors. It's the bad actors that cause these things to have to come in effect, and it causes everybody else to have to follow those same rules. And so, with that's where this is meant to get to, where we can put some sort of regulations around it. And the question ultimately, not only for the committee, but for the council, is how stringent. Do you want it super stringent? Do you want it to be middle of the road? I mean, there's ordinances out there and language in various, in several of these ordinances that are kind of middle of the road, or some are real lenient and some are real restrictive. Okay, and then we have to weigh out, if we go super restrictive, do we open ourselves up for legal challenges and that on the back end? And then what do we want to do? And so, again, tonight, this is simply asking for a committee to be set aside, literally between now, probably in the end of the year. Let's take a end of the calendar year, not fiscal year. Let me just make sure I say that. Calendar year, to help put some of this together, bring that back to council, where we would then certainly wrestle with it and then give direction to legal staff to write an ordinance. Member Owens.
Yeah, I understand we're coming in talking about the dollar amount, not paying a hot tax and motel tax and what have you. The other side of the coin is, we spend a lot of time up here coming in and zoning areas for residential. when this